Hello and welcome back to LiveLaw Academy. Today we are tackling one of the most brilliant and practical concepts in our constitution, that is the doctrine of severability. Imagine this. Parliament passes a new law. A citizen challenges it in court, arguing that one small part violates their fundamental rights. Now, does the court just throw the entire law into the trash with all the hard work and all the good parts just gone? No. That would be like throwing a book away just because one page has a typo. And that's where the doctrine of severability comes in. It's the court's way of being a surgeon, not a demolition crew. They use a judicial scalpel to surgically remove the bad part while saving the rest of the body of the law. Today we will break this doctrine, what it is, how it works, and the landmark cases that every law student and constitutional enthusiast needs to know. The legal foundation for this is Article 13 of our Constitution. It says that any law that is inconsistent with fundamental rights is void, but only to the extent of such inconsistency. This is the heart of severability. So the rule is simple. If the unconstitutional part can be separated from the rest of the law, then only that part is struck down. The rest of the law, which is perfectly valid, stays intact and continues to operate. But if the valid and invalid part are so deeply intertwined that you can't separate them without the rest of the law losing its meaning or purpose, then the entire law falls. To decide this, courts look at the legislative intent. They look at law's purpose, history, preamble, all the clues they can find. Let's see this in action with some landmark cases. Our first case is RMDC versus Union of India, 1957. This is a classic example of severability. The petitioners ran prize competitions, like crossword puzzles or quizzes. They challenged the Prize Competitions Act 1955, arguing it was too restrictive. The Act's definition of prize competition was very broad and seemed to cover everything. The petitioners argued that if any part was unconstitutional, the entire Act should be thrown out. But the Supreme Court had a different idea. It used the scalpel. The court observed that Act's main goal was to regulate gambling, which is based on pure chance. Competitions based on skill, like a quiz, are not gambling. So the court did something brilliant. It did not strike down the entire Act. It simply declared that the Act was invalid insofar it applied to competitions based on skill. The part of the law regulating gambling competitions remained perfectly valid. The legislative intent was saved and the constitutional rights were protected. Next, a case from political arena, Kyoto Holohan versus Zashilu, 1993. This is about the anti-defection law which was added as the 10th schedule by the 52nd Amendment. The goal was to stop politicians from switching parties for personal gain. The law gave the Speaker of the House the power to disqualify a member. But here is the problem. Paragraph 7 of the 10th schedule said that Speaker's decision could not be reviewed by a court. Judicial review is a core part of our Constitution's basic structure. Can you remove that power? The Supreme Court said no. But what about the rest of the anti-defection law? The court applied the doctrine of severability again. It held that the exclusion of judicial review in paragraph 7 was not essential to the anti-defection framework. The main law could function perfectly well without that one unconstitutional part. So the rest of the 10th schedule was saved. Next is the recent case Union of India versus Rajendra N. Shah 2021. This involved the 97th Constitutional Amendment which added Part 9b to the Constitution, dealing with cooperative societies. Cooperative societies fall under the state list. Any constitutional amendment affecting state parts requires ratification by at least half the states under Article 368. But this amendment did not go through that process. The Supreme Court held that Part 9b, insofar as it applied to state cooperative societies, was invalid due to lack of ratification. But what about multi-state cooperative societies? Here, the majority applied the doctrine of severability. It was held that the provisions dealing with multi-state cooperatives could stand on their own. Article 243 ZR, for instance, referred to central laws, not state laws. The court treated this as if it were a separate subchapter within Part 9b. So, the part relating to state cooperatives was struck down but the part about multi-state cooperatives was upheld. Justice K.M. Joseph dissented, arguing that the entire scheme was designed to be uniform and holistic. Once you strike the core, the rest becomes unworkable. But the majority found functional severability and retained the valid part. So as you can see, the doctrine of severability is not just a dusty legal concept. It's a powerful tool that allows our courts to be effective. It protects our constitutional values without bringing down the entire legislative house of cards. It's about preserving legislative intent and ensuring that democracy and governance can continue to function smoothly. If you found this video helpful, please give it a thumbs up, share it with your friends, and subscribe to LiveLaw Academy. Let me know in the comments below which other landmark cases or legal doctrines would you like us to explain next. Until then, keep learning and stay constitutionally curious. See you next time.